Hi guys, I hope you had a fantastic time with your family. Um, I just wanted to create a kind of a quickish video, talk about our last chapter. We did it. I don't have any feedback because you didn't have to submit anything, but I would like to remind you what we need to do for our last assignment, which is our PDO. Okay. I'm gonna go and share Moodle really quickly. And again, I would like you to go watch the video from last week. I have a lot of information about your PDO. Excuse me. However, however, I want to make sure you understand what you need to do, right? And it has to do with a visit at a facility. If you can and you feel safe, please do it as soon as you can. If you cannot describe a facility you have already visited, if you can call them, I would be great. Collect some information um, about maybe changes pre and during COVID, whatever you think would be important, appropriate, significant. Okay. Again, if you have any questions, just let me know. Some of you have emailed me already, and thank you. Okay. One good alternative would be to maybe call Charles. And Charles used to be one of our majors, and now he's working at Eclipse in Plattsburgh. He could just maybe give you a little bit of help. Eclipse is still open. You can ask for him. Um, yeah, that's pretty much about um, our PDO. Um, our FLO. What I was looking at the wrong course, but the main idea is the same. It's not called a PDO; it's called FLO, Final Learning Opportunity. So again, everything else I said is the same. You can call if you need to call somebody, and I suggest the Charles from Eclipse if you can, if you want. That's it. Make sure you watch again the video from last week, understand what the deadline is for the FLO, click on this, right? And also we have two more learning opportunities. And these two learning opportunities have to do, one has to do with the business basics and planning, okay? Both of them due on the 6th. This one, you have to go to salary.com, put in there personal trainer or personal training, whatever you like, and the location, and then you get some results. I want the median, like in the middle, right? Not the lower, not the highest, not the lowest. I would like and the base salary, not the benefits, right? That you get per year. And then I have also here maybe a useful resource if you want to read it. And then, as I say, having that in mind, and in no more than 2 paragraphs, how would you create interest in or promote your services as a personal training platform in New York? So you know now how much you should, on average, charge. Are you going to go above it? Are you going to go below it? In any case, how are you going to promote your business in Plattsburgh, New York? You're not in New York City. You're in Plattsburgh, New York. So I want you to think all that because that's pretty important. Okay. Deadline Sunday the 6th. 3 of you have already done it. Awesome. Now, one more that has to do with what we're going to cover today is a law 28, true or false. 5 questions, pretty straightforward, has to do with sexual harassment. Okay, everything All the information for this one is in the book. Nothing tricky, nothing ambiguous, pretty straightforward, and that will be the last one. Okay, before your FLO, everything you need about your FLO is in our syllabus. It's also down here. Okay, the deadline for our FLO has to do with our last synchronous meeting, which is on Monday. Also, I want to remind you that this Tuesday in 2 days, I will hold our last office hours from 8 to 12:30. In case you want to join me, you have any questions. The blade deadline for your FLO is Monday at 3:45. Okay. So make sure you have whatever you need to have up to that point. And it's at 3:45 because that's when our last synchronous meeting is going to end. So we're going to have a synchronous meeting in our finals in our final week, our last week. And you can even ask me questions during that meeting. That meeting will last for 45 minutes. And at the end of the meeting will be the deadline of the FLO. Okay, so if you have some simple stuff to edit, you will still have a chance even during our last synchronous meeting. So office hours on Tuesday and last synchronous meeting on Monday the 7th. FLO due on Monday the 7th, LO 27th, 26th, Sunday the 6th. That's what we got. Okay, I'm going to finish this video by covering chapter 22, and that will be it. Good. All right. I'm going to stop sharing this, and I'm going to share PowerPoint. If I find it. Try again. Share. There we go. So this is our last chapter, guys. We did it. Okay. And this has to do with the legal issues and responsibilities. And we'll always talk about training, training, but before we even start training, we need to understand liability. So there may be some liability issues that we need to know. We need to know the industry standards, as you can see, because guess what? When there's physical activity and exercise, there's always a possibility of injury. Okay, and since there's a possibility of injury, it's not that we can avoid risk, right? But we can minimize it. And that's what we're trying to understand today, that there is liability, there are industry standards, there's always risk if you are into this business, but there are ways to try to be proactive and minimize it. Okay? All right. This is what we're going to cover today. So let's talk about the very first thing, which is minimizing risk. Okay, the very first thing we can do to minimize risk is to have the proper qualifications. So what is that? Well, it really depends. It depends on the state and on the laws. However, by, for example, getting certified, okay, that by getting certified by a nationally recognized organization such as ACSM, okay, that shows that you have the minimum, at least the minimum proper qualifications to work as a personal trainer, right? There may be some additional based on state, but at least you have that minimum standard of qualification. Now, you see the second dot or dash has to be about accurately presenting qualification. So if you say you're ACSM certified as a personal trainer, you have to be truthful, okay? You can have a personal training certification from another organization, or you can be certified as a group instructor, group exercise instructor from ACSM. You have to represent qualifications accurately. Also, they need to be active. So if you were 5 years ago, it doesn't mean you're still an active ACSM CPT. Okay, so we need to remember this, and of course, always have records, and also always have continuing education units. So a lot of times, for example, the Greater New York ACSM conference was 2 weeks ago, right? If you attend, you get those continuing education units or credits. And that's one of the ways to keep your certifications. So you keep all that, and that's important, right? Um, we've talked about screening, right? Pre participation screening a lot. Remember Part Q plus, and then after health assessments, we may need to refer the client. We get the client back. They may start. That we do the fitness assessments. So there's so much going on in order for us to know that they are safe to work with us and what is safe. Okay. So we talked about all these pre-participation screening assessments, and I hope you remember them. I hope you remember the algorithm that we use, right? Um, there's a lot of crucial information that we get there, but the important thing is collect that information is one thing. As you can see, interpret, evaluate that information is another thing. Because we collect all that information, we have to combine it and make a decision. Should we refer them or not? Okay, for example. And then if everything is okay, we move to the fitness evaluations. Remember, we may do like a 1RM bench press. Okay, we keep records of everything, and that's really important. As a good friend of mine used to say, just in case. Just in case. Okay, from this perspective of minimizing risk if something happens. All right, scope of practice, a very useful term to understand, um, because we'll have a lot of issues if something is out of scope, right? So what is scope of practice? A good way to teach it for me and a good way for you to understand it is that is a continuum. You can go from here to here, or there's a framework, there are like some boundaries. You can move inside this area, you cannot go outside that area, right? And we are in a business that we cooperate with other people, medical doctors, physical therapists, registered dietitians, chiropractors. So we need to offer some kind of service which can um, complement what they're doing and vice versa, right? So something that I do, they cannot do. Something that they do, I cannot do. Which I hope it makes sense. This is from the American College of Sports Medicine Code of Ethics. Personal trainers practice within the scope of their knowledge and skills. Okay? Personal trainers will not provide services that are limited by state law to provision by another healthcare professional only. Um, one side note, personal trainers are not considered healthcare professionals yet. Um, and that's good or bad depending on how you're going to see it. What I can say in general is that if you know somebody else who's providing the service, like a registered dietitian can actually sit down and write a diet plan, that means we cannot do it. If somebody else can do it, we can do it, right? A doctor can diagnose, we can. Okay, so a general rule of thumb is we do something in a continuum of services, and we all help each other in a kind of an interdisciplinary approach here. And all of us, chiropractor, an MD, a physical therapist, a personal trainer, we're all working together to help the client. There is some common ground between those professionals, but usually what I do, a physical therapist cannot do. Okay, what a registered dietitian does, a medical doctor cannot. Um, We're going to talk about all these things in a little bit about waivers, consent form, liability insurance. Um, in general, as I said before, keep all records, keep everything written, just in case, and definitely maintain your certification. When you're not sure, let's say you move from California to New York, you're not sure if the laws are different here, ask. Okay, don't wait to get in trouble. All right, so as I said before, we're not into the medical advice. So there's no claim against us compared to that part. However, there are claims against personal trainers that have to do with dietary advice. Okay, a classic one has to do with supplements, as you understand. Okay, and when we talk about supplements, you know that we cannot sell supplements. Okay, and the case is almost 20 years old now. 20 years old now. It has to do with Crunch Fitness. We have a personal trainer. He sold the client supplements. One of them had ephedra. That client had high blood pressure, and then that client took ephedra. You understand that that's not something that you would suggest to a client like that, and the client won the case. All right, there are other cases as well out there. And another case that has to do with the client taking more than the recommended dosage. And still the client won the case because the trainer or the fitness facility in that case had a package that you could buy a membership, right? And they would sell you some supplements as part of a better deal. So we really need to be aware we cannot of us not being able to sell supplements. Okay, that's out of scope. Now, the last thing is really important. The last two things are important, actually. If something happens, think about any company that makes food supplements, they're not going to cover. They don't have liability coverage. Are you impressed? I was impressed too when I heard that the first time I heard that. On top of that, you know what FDA is? Well, FDA, for example, also does not really check what's in those supplements. Unfortunately, unfortunately, FDA will check once something bad happens or once somebody make a claim. Unfortunately, so in a way, if you are a trainer and you do sell supplements and something happens, get caught, you're pretty much on your own. So be really careful, okay? Just do me that favor. Um, all right, so once you know the risks, you need to create a risk management program, right? Because you're trying to be proactive. And all this, as you see here, are known risks: the physical setting, the equipment used, the training techniques, and we're going to cover most of them, as we go. The services, the degree of emergency preparedness and responsiveness, and record keeping. All of them are known. So at least our risk management plan should address the known risks, right? That would make sense. Okay, the very first thing we should offer to a client when they're using our facility is safety. And I hope we all understand that. That's really, really important. If we don't, we go under tort law. And in this case, we're talking about premises liability. Okay, we're going to define tort law in a little bit. There's a box. So we have some legal terminology today, but it is important. It is important to understand that just in case. So we can avoid the risk, okay, or minimize it. All right, so the system has a lot of standards. We're not going to go over all of them. There are other courses, but in general, safety in our, let's say, just building or room where we train them is, as you understand, the very first thing we should provide. And that will be the first thing in our risk management program. All right, key terms. We need to stop here for a second. I start with tort law, which is all the way at the bottom. That has to do with civil wrongdoing. That's what it is. Risk management is that process we're talking about. It's a whole program that we're trying to minimize risk and make sure, and how do we do that? We try to attack the known risks. All right. Now, the most important term from this box is negligence. A failure to conform one's conduct to a generally accepted standard or duty. What is a generally accepted standard? It really depends. It really depends. Okay, so we have those industry accepted standards, and a lot of times, if you go to court, when somebody goes to court, when a personal trainer goes to court, we do have because the judge doesn't really know the specifics, they're going to bring in somebody who does know the industry, and they're going to ask them what's the industry accepted standard. So if the service we provided is below, guess what? They may make a case for negligence. Now, what is a waiver? We're going to come back to negligence in a little bit, but what is a waiver? Have you ever gone to a gym and they make you sign a paper in the very beginning? Okay, let's see what this paper is. An agreement by a client before beginning participation to give up, relinquish, or waive the participant's rights to legal remedy in the event of injury, and this is the juicy part, even when such injury arises as a result of provider negligence. So what are we signing? We're signing a paper that says, even if we get injured and it is your fault because you did not conform to the generally accepted standards, it's fine. I waive that. You can do it. No problem. I'm not going to pursue it. I'm not going to prosecute. Okay? So negligence and the waiver are the most important things from this box. Another thing, we should have an emergency response. And most of the certification now, before you even take the exam, sit the exam, right? You need to provide CPR and also in some of them AED. Okay, so we need to have that certifications, those certifications before we even sit the exam. Now, in general, if you're working at a facility, there has to be an emergency plan. You know what to do if this happens, or this happens, or this happens. And if we have an incident or an accident, we have to document everything. And we're going to talk about that in a little bit too, but everything should be documented. Just in case. All right, guess what? When we talk about premise liability, what do you think is the very first cause? Slip and fall injuries. Okay, so we need to be very, very, very sure that everything is safe, as I said before. Wherever we take our client to train them, everything is okay. Everything is the way we're supposed to. And if it's not, do something different. Reschedule. Be creative. Go use something else. Okay? If the equipment is not properly stored, that's another thing. I want you to understand that, you know, when we talk about slip and fall injuries, a lot of people think about treadmills, which is fine. We're going to talk about treadmills in a little bit. But there are cases that they may sound crazy. A guy was trying to change the channel as she was doing cardio, and he fell, and he sued the gym, and he won. So be mindful, please. Um, of course, we need to educate clients. Of course, they need to wear the proper clothes and the proper shoes, right? And for example, when I was at Baylor and I was in charge of the personal training department, as I told you before, we had a lot of trainers. If the clients didn't wear appropriate shoes or clothes, we're out. We're done. They knew that. Okay, so the trainers were trained to request that. Um, Equipment, of course, has to be from. You have to buy it from providers that you trust. Okay, and you need to educate the clients before they use them. And we'll have another case. A guy had never used treadmill before. The trainer didn't really explain. He fell, twisted his ankle to the gym, the trainer. Won the case. All right. So make sure you buy the right equipment and educate the clients. Free weights. With free weights, as you know, there's a higher probability of injury because the weight moves in all three planes. So we have less stability. It's more unstable environment. So there, again, you need to explain, you need to make sure you show them, you're there to correct them, and you use every movement as an assessment, and do not increase the intensity if they're not ready. We'll have another case here that a guy, so the trainer pushed the client too much during squats, although he did express that he wasn't comfortable, and the trainer added weight, and the client went into rhabdo, which is um, I'm not going to explain what rhabdo is, but it can get really serious. You can get hospitalized and die. Very rare, but do not push the client too much if they're not ready. With the weight machines, less porting is required. They're supposed to be less dangerous, right? Write everything down, educate, make sure, very important with machines that they're maintained. So we have records when they're maintained, how they were maintained, something changed, because most common thing is something breaks like a cable, okay, in these cases. The last thing, the equipment has to be professional. Because there's another case that a guy was at a hotel, was training at that hotel. I'm not going to say the name, but huge chain. And something happened. with the equipment. Turns out the equipment was not commercial. So he won. Excuse me. So again, be proactive, please. Cardiovascular machines, treadmills are very, 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 very popular. Make sure everything is maintained properly, and you explain how to use them. And I already explained the case of that guy that fell off a treadmill. All right, here we'll have sexual harassment, and that's your last along. So tactile spotting is we need pretty much touch the client, and it is necessary. It's not that it's not necessary. There are cases that tactile spotting is very necessary. There's no other way to do it. Okay. Make sure you explain. Make sure you ask first. Make sure you tell them exactly what you're going to do, so you avoid weird situations. Also, as you can see, avoid closed door situations. Even when you're doing some kind of fitness or anthropometric assessment, like waist circumference and stuff like that, be careful, right? Have a third person in the room if possible. Okay, especially if your client is of the opposite sex, or I'm not sure if I want to take it there, but make sure you're covered. Okay. And as you can see in the last one, the last dot, is not that you can't have a relationship with the client. You can have a relationship when they're still your client. So once you have a relationship, it can't be your client anymore. So you have to choose romantic relationship or client. Okay? Yeah, it's happened. It's fine. It's fine. It's happened to me. Trainer came. Okay, right, fine. You can't train this person anymore. I have to switch you. Done. Nothing more, nothing less. That's it. Cool. By keeping it a secret can jeopardize your job, like with your supervisor. But also, if something happens in the relationship, you never know how things are going to turn out, and you may find yourself in a weird position. So just keep them separate. All right, not a lot of things left to cover, but this is important. If they take it to court, they're going to try to prove that you were negligent. In order to do that, we need four things, all four of them. Be careful. We need to identify your duty. And duty has to do with the standard of care, like what you were supposed to do. Okay, which is kind of subjective a lot of times. So that's why we have those industry standards. So let's say we operationally define the standard of care. Breach of duty means you didn't do it, right? And the proximate cause means that because you didn't do it, there was damage. So the proximate cause is going to connect the breach of duty with the damage. What I mean, let me give you an example. You were squatting. You wanted to max out to go for a PR. Okay, I said, cool, do it. And then my phone rang. I'm your trainer. Start talking on my phone, walking away. You didn't stop. You went for that set. You went for that PR. It's too heavy. You weren't ready for whatever reasons. You destroy your right knee. If you can go to court and put the standard of care, breach of duty, and that because of breach of duty, that's why you hurt your knee, boom, you're good. But for example, you can come and try to prove in court that you hurt your, I don't know, something really relevant, like your left eye hurts because you were squatting and I wasn't spotting you. So you have to prove that there's a connection between the breach of duty and the damage. Or like, I'll make another example that's even more crazy, like that you have asthma attacks now because I wasn't there when you were going for your PR for squatting. So you're trying to connect me not spotting you during squatting with asthma. Or you have high cholesterol now because you know what I mean? So there has to be a proximate cause that will connect the breach of duty with the damage that you're claiming that happened because of that breach of duty. I hope that makes sense. Business plan. So here, we need to create a business plan that has to minimize the risk again, but it really depends on what kind of business we have. We talked about business before. When you are an employee, it's different. And you should always try to ask your employer to cover possible damages inside and if possible outside of the gym. You train somebody outside the client. Then if you are the sole owner, you are part of a liability company. That of course affects if somebody's gonna go after your personal assets. All right. So all these are important things to consider as you're trying to minimize risk. And again, because we don't know the law, more specifically, we don't know the law in all states. Ask people, ask the professionals who do know it. Okay, some management risks. Have all these forms, have all these policies, and apply them. That's your first line of defense. So have a waiver, make them sign it. Good. You're very good. Right? The second strategy. You have all these forms, depending on the laws, and the language is in there is clear and unambiguous, and you keep them indefinitely. Yes? Okay, just in case. Third strategy, carry some professional liability insurance. We're going to talk about how much ACSM suggests. That's important. I don't know a lot of people who do that, but that would be a great strategy to minimize risks, just in case again. Try to protect your personal assets if something happens. And the last one, of course, is talk with people that do know the law. But before that, is something that should be simple to understand. But I guess we need to point it out. If you have a good relationship with your clients, if your clients like you, really like you, there's a way lower probability that they're going to sue you. Okay, so have that relationship management that we've talked before. Like have that relationship. Okay, and again, I'm going to connect that with the sexual harassment. The trainer-trainee relationship is really strong. It should be strong. It has to be strong, right? That will help you with your management strategy and minimizing risk for sure. Don't take it all the way to the other side though and create a romantic relationship while you have a professional relationship as well, because that won't help. Okay. We talked about all these policies, right? I hope you remember all of them. PARQ Plus, HHQ, the referrals, the medical clearance. Then we moved the fitness assessments, all the progress notes, or if something happens, the incident reports. All of these are important. All of them have to be filled out, and all of them have to be kept. This is an incident report. This is what I'm going to say now. It's really important. Do not leave anything blank, right? If something is NA, right? NA, in this case, blanks are not good. Blank spaces can really backfire. That's one thing I really try to instill in my trainers when I was at Baylor. If something happens, it happened. Let's move to the incident report. Everything has to be filled out. Everything. One way or the other. Um, Okay. Okay. So let's talk about this for a little bit. Assumption of risk, sometimes called informed consent. And there we explain the risks, the benefits, why you have to participate. A lot of times we do it in research as well. So we bring you in and we do some kind of experiment. Excuse me, we put you on treadmill. You have to do like we measure something. Let's say before we put you on the treadmill, we put you on the treadmill for 20, 30 minutes, whatever. You finish the protocol, you get down, and we measure something, right? And we're trying to prove a hypothesis or disprove it or whatever. And when you participate, you cannot participate unless you sign the consent form, right? The consent form explains the risks, the benefits, who will benefit from the results, are you personally going to benefit from the results, or the scientific community, what you're supposed to do, what you should expect to do, what are your obligations, what are our obligations as researchers. Everything is written down and explained. Even the form of the chair of the ethical committee who approves the experiments or the research project is in there in case you want to call them. So you have to sign it. If you are below 18, you have to sign it, and your parents have to sign it. So it's a very formal document. That cannot really help you with if something happens if you take it to the court. Okay, what can really help you is waiver. Okay. In any case, the language and what you have to write is a lot of times we follow what other people do, like in our labs. We have one we took from the legal department and we just edited a little bit, right? But if you want to write one from scratch and you don't know what's going on, talk with a professional, right? This is a consent form or type of a consent form, and this is a waiver. Um, what I want to read here is second paragraph, okay? It says, for and in consideration of whatever allowing me to take the fitness evaluation, I hereby release covenant not to sue the officers, agents, members, and employees of each from any and from all claims or actions, including those of negligence. Okay, that's a waiver. Very useful when you have it. Now, when you sign it, think about it. All right, so here, if you can have a personal liability insurance, HSM recommends $2 million. Okay, confidentiality has to do about your data, right, that you share. That's really important. Who can see them? They're protected now under HIPAA, right? That's really important. 1996 and 1996. And these are our take-home points of our last chapter. All right. The personal training industry is in a rapid state of growth and redefinition. More professional opportunities, however, increase expectations of responsible professional conduct. Today's personal trainer must understand the potential risk of risk exposure and the legal issues and industry standards and guidelines that surround these issues to deliver services confidently and to proactively manage risk. The most successful personal trainers will always keep in mind that the core of personal training is ultimately personal, to protect the best interests of the client at all times and in all ways. All right, guys. Tuesday, office hours. The 6th, we have 2 LOs due. And the 7th, Monday, final week, we'll have our last synchronous meeting, extra points credit, 3 o'clock, 45 minutes. At the end of that synchronous meeting will be the due date, it will be the FLO will be due. That's what I was trying to say. Okay, thanks guys. Again, I hope you had an awesome time with your family, and I'm wishing you an amazing week. In the meantime, lift intentionally.